There is a piece of estate planning advice that just absolutely refuses to die, and it may be one of the most ridiculous ideas still showing up in wills and trusts. It's worse than an old wives' tale that tells you, oh, you shouldn't let your children swim until more than an hour after they've eaten. Except this myth can cost real money for your estate. If someone wants to disinherit an estranged child and they're told to leave that child $1 because that somehow proves that the child was not forgotten and somehow keeps them from challenging the estate plan, it sounds clever until the estate actually has to be settled. Then the family finds out that the $1 did not keep the estranged child away. It dragged them into the paperwork, forced the executor or trustee to deal with them, gave them notices, gave them a seat at the table, and gave them the chance to make the entire process slower, uglier, and more expensive. The worst part is that this bad idea is not just floating around because some clients heard it from a neighbor or read it online. It's coming sometimes from the attorneys. They put out this nonsense into estate planning documents as if it's standard practice and that's just the way it is. The problem is, if an attorney actually took the time to think this through, they'll see it's not effective. It actually leads to more potential challenges because it isn't a deterrent. Why leave it then? Maybe they have always done it that way. No one told them any different and they just didn't bother to think about it. That could happen. Maybe they just haven't thought it through. Or maybe for the cynical people out there like me, hey, doing it this way provides extra paperwork, which is billable hours, and then the fight over the estate, if it happens, it's going to lead to even more legal fees. So the attorney is building in future business, and that's not the way to serve your clients. So in this video, we're going to go through the vulnerabilities with both a will and a revocable trust. But in both cases, just leaving $1 makes things more vulnerable than it needs to be. So first, let me tell you how this whole thing came about. And it's one of the cases that I actually remember way back from law school. There was a couple, and for their particular religious faith, you could not marry somebody outside of your religious faith. If you did, then that child is dead to the family, to the church, to everyone. So they had a son, a daughter, and then another son, and that youngest son had the nerve to go and marry somebody outside the religious faith. And so what ended up happening is they're dead to me. So they went to see an attorney. The couple went and said, okay, yeah, well, all right, well, how many kids do you have? Oh, we have 2 kids. All right, what are their names? Okay, and you want everything to go to them equally? All right, well, so we drafted the will. It says here you have 2 children and blah, 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 and these are the beneficiaries, signed it, dated it. And then, of course, the parents passed away, and the 2 children are expecting to receive anything, and the third one shows up and says, hey, wait a minute, I'm a child. They obviously could not possibly be in their right mind if they put into their will that they only had 2 children. And you know what? The court said, you're right. How could they possibly have been in their right mind if they didn't? And they tried to explain that, well, this is, this in their religion, it's this, and in their religion, it's that, and this is how it's treated. It's as if they're dead. No, a will has to state, if you're kind of proving that you're of sound mind, you need to know who your children are, whether they're beneficiaries or not, and listing that you only had 2 children when you actually had 3. That's what happened. So, well, hey, why don't, instead of just not listing them and saying they're dead to me, we'll give them $1. What does that do? It doesn't really do anything. But that's the case that it came from. So it was because of this religious thing that, oh, they're dead to me, that they treated that the child never existed. No, you list them and then you specifically disinherit them. The $1 thing doesn't do anything. All it does now, when it's a will and it's in probate, they're now a named beneficiary. You have to list them in all of the probate paperwork. So all along the way, whenever there's a notice that has to go out to the beneficiaries, well, there you go. You have to provide them that notices. So now If you didn't know where they were, you have to go out and find them. Have to give them these notices. You have to provide them all the paperwork and the receipts, and they have to sign off on it. What happens if they don't sign off on it? Well, now it's more paperwork. Depending on the state that you're doing this in, it could be as easy as, well, okay, it was sent and you sent it by certified mail and they didn't sign off. Okay, fine. We're going to close the estate anyway. In other cases, it's, well, no, we have to have a special proceeding. We have to specifically put notices to beneficiaries in the newspaper, and they have to come forward, they're a known beneficiary, whatever. And look, they can just cause it to drag on. Or if they don't like the fact, they find it insulting that you left them $1, well, now they can challenge it in probate. And let me tell you something, in a lot of cases, when it comes to probate, if there's a challenge, they get the attorneys, they go and challenge it. Hey, they couldn't have possibly meant this. Here's this thing that happened. They saw this doctor around this date. Attorneys go, well, I don't think we're going to win, but you know what? We'll give it a try. We do have a good faith basis to at least try. And the attorneys often are going to get their fees paid out of the estate, even if they lose. Well, now suddenly that's even more money that's being lost because you decided to actually just give them $1 instead of ignoring them. You just ticked them off, you made them mad, and you brought them and dragged them into that estate. Now, what about with a revocable living trust? All right, now this is a little more solid. And I really recommend you take a good hard look at revocable living trusts if you're going to end up having a beneficiary that's disinherited, or if you've got children and it's not equal. Well, okay. Now the trust keeps everything out of that court process, so it's more efficient anyway. But here's the secret sauce, and you actually learn a lot more about why in my book, Estate Planning Basics, which is available free digitally at freetrustcourse.com. We'll mention that again at the end. What ends up happening is, because it's not in probate, they're actually having to go file a lawsuit against the trust to challenge the terms of the trust. And now suddenly they're not being paid out of the probate process. And so the attorneys that they want to hire are not just doing it because, hey, the court's going to pay us. No, they're going to have to come up with their own money in order to challenge the trust. So that's a huge deterrent, because one of the things that I've kind of found out as more of a life lesson than anything else, people in this world who want something that they're not entitled to rarely want to put up their own money in order to get it. So that's how the trust is going to help dissuade that. But still, you don't list that you're giving them $1, because even then that's more paperwork. And at the very least, you have to track them down to get them their $1. All you do is you can do one of two things. And this is where we're getting to the actual solutions that will work. All right. First, this is what we do as a standard practice. We list them as a child, and then we specifically disinherit them. And now you do also have to make a decision here. Are you just disinheriting the child, and they end up being treated as if they, quote, died before you, or are you also disinheriting the child and their descendants? So it's cutting out any grandchildren that might have come through that child. You have to kind of make that decision, but you spell that out clearly in the will or in the revocable trust. So it's right there. It's clear. They're disinherited. That's the one most popular technique. Now here's another one which people don't generally like if they're trying to cut someone out. But look, if they really, really think they're going to create a problem no matter what, they're going to challenge it no matter what. Well, then don't leave them $1. Leave them a sum that's actually significant enough that they're going to worry about losing it, but it's not like a full share. Let's just say you have a $2 million estate, you have 3 children, you only want 2 of them to get it. Leave them maybe, that estranged child, maybe $50,000 or $100,000 of it. Now that's real money, but at the same time, it's not a full 1/3 share. So what you're actually doing is saying, hey, look, you're going to end up losing that amount that we're giving you if you go and challenge it. So you've got to couple this in all these cases with strong no contest clauses. So there is something now significant for them to lose if they go ahead and challenge that estate. So that's the second technique, is actually make it so there's something that they're going to lose. All right. So this whole thing about just leave them a dollar, just leave them a dollar, just no. Now, I have seen some trusts that will put in they're disinherited, they receive absolutely nothing, and there's a strong no contest clause. If you contest this, then you get nothing, and you've got the burden of the attorney's fees and all this other stuff. And at the bottom, hey, if they still challenge it, then all they get is a dollar. Look, they have to come forth and challenge it. I've seen it, but it's at the very end. It's not the actual safeguard. That's like putting a little piece of tape over the door frame and saying, oh, well, nobody's going to break into the house because there's that piece of tape. No, it's not going to do anything. So, again, if you want to know more about getting rid of challenges, because that's one of the 4 big reasons that we see that people use revocable trusts. It costs less, it's less time consuming, it helps avoid contests, and it's more private than probate. Then check out my course at freetrustcourse.com. Again, that's freetrustcourse.com. It's completely free. You sign up, you get a couple of emails, but you've got full access to the digital versions of my book, Estate Planning Basics. So you get that in a audio format as well as a PDF. And for those of you who absolutely want video, we actually do a read along that's combined with the audio. So you've got 3 different ways to learn from that. So I hope you found that information useful. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.